5 seconds to go. Start. It was next urged that even if the application under Order 9 Rule 7 in respect of Suit 134 of 1956 was incompetent, having regard to the stage which the hearing of that suit reached, when that application was made, still the order passed in Suit 20 of 1953 in the application made for the restoration of that suit under Order 9 Rule 9 was competent, and that the order passed on that application operated as res judicata to the maintainability of the application under Order 9 Rule 13 in respect of Suit 134 of 1956. We consider that there is no substance in this submission. The ground urged for applying the rule of res judicata was that the court had, at an earlier stage, ordered the joint trial of the three suits 1023 of 1951, 20 of 1953, and 134 of 1956, and that as the three suits were thus linked together, the application made for the restoration of Suit 20 of 1953 constituted a finding by a competent court that there was no good or sufficient cause for the non-appearance of the appellant in court for any suit on May 29, 1958. The suits were no doubt ordered to be tried jointly in the sense that the evidence recorded in one suit was to be treated as evidence in the other suits also, Suit 134 of 1956 being treated as the main suit in which evidence was recorded, but that affords no basis for the contention that every application made in one suit for the relief which is pertinent only to that suit must be treated as an application made in every other suit. Thus, for instance, in the present case, if no application were made for the restoration of Suit 20 of 1953, which had been dismissed for default, it could hardly be contended that because of the application made in Suit 134 of 1956, it would serve the purpose of an application for the restoration of that other suit. Similarly, if an application had been made for the restoration of Suit 20 of 1953 and the court found that there was sufficient cause for setting the dismissal aside, that would by itself hardly be a ground for setting aside the ex parte decree in Suit 134 of 1956. These features are sufficient to demonstrate that the circumstance that the suits were being tried jointly has no bearing on the matter now in controversy, and that so far as regards the ex parte orders in the three suits, each had to be considered independently and had to be disposed of also independently, notwithstanding that the same grounds might have sufficed for the relief prayed for in the independent applications. There is another aspect from which this matter could be viewed. The point at issue in the application under Order 9, Rule 9, filed to set aside the dismissal for default in Suit 20 of 1953 was whether the plaintiff had sufficient cause for his non-appearance when the suit was called on for hearing Wide Order 9 Rule 9. The suit called on for hearing in that rule obviously refers to Suit 20 of 1953. A decision therefore that there was no sufficient cause for the non-appearance of the plaintiff in that suit would not be idem question with the matter which arose for decision when the application under Order 9 Rule 7 was made in Suit 134 of 1956 notwithstanding that the facts upon which that issue depended was similar and possibly identical. This is a further reason why we are unable to accept the submission of learned counsel. The last of the points that was urged by Mr. Pathak was that the decree that was actually passed in suit 134 of 1956 was not in reality an ex parte decree but one on the merits. It was urged that the proceeding on May 29, 1958 satisfied the conditions of Order 17 Rule 3 and not Order 17 Rule 2. There are several reasons why this submission is entirely without substance. In the first place, during the entire proceeding right up to the hearing of the present application, which was made under Order 9 Rule 13, the court as well as both the parties proceeded on the basis that the decree was passed ex parte. The order sheet on May 29, 1958 we have extracted earlier contained a direction by the court that the case will proceed ex parte for the reason that counsel for the defendant reported no instructions, and it must be noticed that by that date the entire hearing was over. The application that was made to set aside this order to proceed ex parte was filed on the basis that the previous hearing was ex parte and was contested by the respondent on the same basis. Stop.